Glossary of Legal Terms, Statutes of Limitations. Brought to you by yourlegalegup.com, your advantage if you're being sued by debt collectors. Hi everybody, this video is part of our glossary series where we explain legalese to ordinary people. You will find the link to a page linking all the glossary videos in the video description below, also the glossary itself. We will tell you what the term is, what it means, and what the legal context is. We'll point you to other sources of information if necessary, and then discuss what it all might mean to your defense. This video discusses statutes of limitations. As you'll see, it's easy to say what a statute of limitations is in theory, but it can be much harder to say what it will be in any particular case. Let's do the easy part first, the theoretical definition. A statute of limitations is a time limit to legal liability, an expiry date for legal claims, you might say. This period of limitation will be set by statute, that is, by a law enacted by your state legislature. That's why it's called a statute of limitations. Since there are a large number of possible legal claims, they aren't all specified by statute. You may have to look at categories, and that can get complicated. The period of limitations can be very, very different for two similar things. For example, when I was practicing, the statute of limitations for a suit on account was 2 years, but for a suit on a written contract was 10 in my jurisdiction. But most credit cards at that time had written contracts, so which was it? And I think it turned out after much litigation to be 2, but don't hold me to that. Now, before we go any further, let me talk about what action ends the applicability of the statute of limitations. It's the filing of suit, not the service of the suit in any jurisdiction in which I'm aware, and not judgment. In other words, the statute of limitations controls what the time limit is for starting a lawsuit, only that. And the reason for this is that there are two major considerations to govern the way the law works. In the first place, and most importantly, the law hopes to get it right on the merits. You fight about it and justice prevails, or that's the theory in our legal system. On the other hand, people need to be able to go forward without always looking back over their shoulders. Legal rights and people in our legal system need what's called finality. Once a lawsuit is filed, there's no longer any real question about whether you're going to have to fight. Bring it on soon enough and there's going to be a lawsuit, but bring it too late and the law thinks it's time to move on. There are things that toll the statute of limitations, that is, stop the clock from ticking. And these aren't always obvious. They aren't always obvious to anybody. They're beyond the scope of this video, though. In debt cases, that usually isn't an issue. It's more of a challenge to figure out when the statute started running. Even with laws regarding charge-offs, it isn't always clear when the clock starts on a credit card account. Some of you may have been sued for accounts stated. One reason they do that is they say the last time you got a bill is the date the statute starts running. And the limitations may be longer as well. You can be sued under more than one theory for the same debt, as the account stated claim shows. And these claims can seek slightly different amounts of money and have different statutes of limitation and proof. You have to look at each claim separately and fight all of them to keep from owing anything. Fortunately, they're all similar, and the debt collectors have most of the same problems with all of them. If the lawsuit against you has been brought beyond the statute of limitations, you will need to plead the fact. That is, you'll need to put it in your answer. Whether the burden of proof is on you to show that it's too late is not always clear, but because it's a legal question, that isn't usually very important. You'll prove it's too late, or they'll prove it's on time. There won't be a tie on this issue. So what I'm saying is, you have to allege in your answer that their petition was brought too late in violation of the statute of limitations, but it's not clear who has the burden of proof on the question. If it's a debt collector and they filed their suit too late, it will probably be a violation of the Fair Debt Collection Practices Act, as well as a reason to drop the case. I say probably because although every court I'm aware of that has addressed the question has said it does. The Supreme Court used language in a recent decision that casts some doubt on that in my mind. I think there are some courts that have held that it wasn't a violation of the FDCPA to bring suit under more than one theory, where one but not all of the theories were beyond the statute of limitations period. If that's your situation, you'll want to think about it and research the question for your own jurisdiction. What you need to do is look at the date any claim against you supposedly arose. If it's beyond the statute of limitations, be sure to say so in your answer. If all the claims are beyond the limitations period, consider whether to file a counterclaim if the plaintiff is a debt collector. Of course, you know you can't take any of my videos as legal advice. They and the glossary are educational. They're made by someone who used to practice a lot of this kind of law, and they're designed to help you develop your own judgment. Most people can represent themselves in debt law cases because of the kind of law it is and the kind of business it involves, but you don't have to do it alone. If you are in fact representing yourself, you may want more help, and that's where our memberships and products come in. You'll find the link to the glossary, as I said below in the video description. You will also find a link to a page linking all of the videos in this series. Helping people protect their rights is what we do. Protect what's yours and don't let the debt collectors rip you off. YourLegalAgUp.com